Good afternoon again. My name's Leticia. I work with Attorney Bruna's office, and it is my pleasure to introduce our speaker today, an accomplished U.S. immigration attorney with over 13 years of experience navigating complex immigration matters. Attorney Bruna. As founder and principal attorney of INLG, she is licensed in both Texas and New York and works at the intersection of global talent and opportunity, advising multinational companies and high achieving professionals across industries such as oil and gas, technology, pharmaceuticals, and many others. Before founding INLG, she worked at leading firms including Ball Global and served as corporate counsel for Santa Fe relocation. Today, in addition to leading INLG, she also serves as general counsel for the Consulate General of Brazil in Houston and for Tramontina. So please join me in welcoming our speaker today.
Thank you,
I feel like I should
Leticia.
clap.
That's an amazing, amazing presentation. I don't know if I'm all of that, but I appreciate the words. Thanks everybody that is here today. As Leticia said, and Jose as well, this presentation will be available later on through our YouTube channel. So feel free to share it with anyone that is interested in learning more about the H-1B visa and its process. Um, INLG is not only me, we have over 80 people working for us, not only in the US, but overseas. And that's why our firm is very successful with customer service because this is our motto. We want to make sure that we don't only provide the expertise that you are looking for, but you are also that you also have a good experience throughout the process. That being said, you are here today to hear about the H-1B visa process and what's new. The good thing is that I know that our audience is very knowledgeable about the H-1B visa itself, so I'll try to be as as quick as possible when I go over the basics of the H-1B visa, and then we'll focus on the two main changes that are happening this cap season, which is the method of selection, the method the lottery will run, which is based on will be based on the level of your salary, as well as the payment of the $100,000 fee for people that will be applying for the H-1B visa from overseas. We'll go over the difference between a change of status and consular processing, answer some of your general questions, and then talk about the self-sponsored option that you have with the H-1B visa and what you need to watch for as you go through that. And the last topic I will cover, and I know that's one of the topics that most of you are interested, is the intersection and how having the F1 intertwined with the H-1B visa process. What's the H-1B visa, right? The H-1B visa is a visa that will allow you to work for a US employer. And of course, you're going to be able to transfer to a different employer throughout the validity of your H-1B visa. The position that is offered to you must require at least a bachelor's degree in a specific field of education, and that field of education has to be related to the position that is being offered. You can remain on H-1B status for up to 6 years, and then that 6 years can be extended in case you
Attorney
have
Bruno, I'm
started.
sorry to interrupt. I don't know if we see your screen, and I think we were supposed to.
I'm sorry, 1 second. Can you see it now?
Yes,
Yes?
yes, we can. Yeah.
Okay, great.
Yes, we can.
All right. Now, did you miss all the slides or just this one?
Pretty sure all the slides.
Okay, so everyone can see it. This is the slide with the contents. This is the slide with my picture, and that's the slide that I'm covering now. So the H-1B visa, as I said, is valid for up to 5 years. You can extend this time as long as you have started a green card application. You can bring your dependents to the US, your spouse and your children. However, they are not able to work in the US. Spouses will only be eligible to work if you have started the green card application and you have one of the petitions approved, in like the availability of visas to move forward with the filing of the adjustment of status. It's not current yet. To qualify for the H-1B visa, you need to have the qualifications that the position requires. So, if the position requires, for example, a master's degree in a specific field of education, however, you only have a bachelor's degree, you're not going to be qualified for the position. However, if you have, for example, the equivalent of a US bachelor's degree and the position requires only a bachelor's degree, you're going to qualify for the position. In other words, you have to be, you can be overqualified, but you cannot be underqualified for the position that is being offered. Now, the company will not be able to tailor the job description to meet your qualifications. The company will have to create and have a position that meets what the industry requires. Because the government will be very selective now, they want to make sure that companies are not favoring just foreign nationals for the H-1B visa applications, but they are being fair as far as providing and offering a position that is also offered to US citizens and green card holders. The H-1B visa process has three main phases. The first phase is the lottery process, which is basically adding your name into the lottery pool. And then if you are selected, the company will have 3 months, 90 days to file your H-1B petition with USCIS. As part of the H-1B petition, the company will have to also get a labor condition application certified by the Department of Labor before filing the H-1B petition with USCIS. So you have to consider this time for the certification of the LCA before filing the H-1B visa petition. And then the third step will be the filing of an H-1B visa at a US consulate or embassy abroad in case your H-1B petition was not filed for a change of status. If you have filed for a change of status, the next step will be basically to change your I-94 automatically from the I-94 from the status that you had before to H-1B on October 1st or at the date that the H-1B visa petition was approved, if it was after October 1st. For Canadian individuals, you don't have to worry about the H-1B visa process at a US consulate or embassy abroad because you are visa exempt. So you have to basically cross the border with your H-1B visa petition that was approved by USCIS, and then you're gonna be allowed entry into the US. In the past, in order to apply for an H-1B visa petition, you didn't have to go through a lottery process that was based on the salary being offered or the minimum requirements for the position. the lottery was 100% random. Basically, anyone that would fall under level one wage up to someone that would fall under the level four wage would have the same chances of selection. And now this changed, and this is something that was already expected. That was something that was already being contemplated by the Trump administration when he was president the first time. But only this time, the administration was able to change that selection to being weighted based on offered salary. The lottery starts with USCIS opening a window of usually 3 months in March for companies to submit the registrations through the My USCIS website. So companies will have to create an account with US in the USCIS portal, and as attorneys will draft the applications so companies can then approve them for submission. So that window, usually based on previous years, would open on March 1st and then it will run until March 18. I don't know if this year those dates will be the same, but just expect that the window will be from beginning of March to end of March. Once that window um, shuts, right, closes, the company, USCIS will send its decision on who was selected in the lottery by end of March, beginning of April. Once the company receives that notification from USCIS, as I said, the company will have 3 months to file the H-1B petition with USCIS. So USCIS stands for United States Citizenship and Immigration Services, which is the government agency that is responsible for overseeing immigration processes inside the US. And that date, that deadline is June 30th, 2026. Based on last year's H-1B cap season, there was only one round of selection. So basically, there are 85,000 visas that the government can issue, 85,000 H-1B visas that the government can issue per calendar year. For immigration purposes, the fiscal year starts on October 1st and then runs until September 30th of the following year. So those, as long as those 85,000 spots are filled, then the government doesn't run a second or third lottery. Last year was the first year that I saw that only one round was conducted. So it might be that this year will be the same. The prediction is that less people will apply for the H-1B because people that are outside the United States most likely don't want to pay the $100,000 fee. So we're going to have that. So the odds of selection, I imagine, will increase, even if you're going to fall under the level one or level two wage of the Department of Labor. So once you know, as I said, the company will have until June 30th to file the petition, and you know whether there would be no more rounds of selection once you receive the non-selection letter from USCIS. Some things to keep an eye on, especially from the company side, it would be any typos on the registration form, such as date of birth, names, and passport numbers, because the passport, the nationality of the passport will guide your H-1B visa process. So if you have dual nationality, make sure that you provide the passport that you're going to be using to apply for your H-1B visa and that it's more favorable to you. So for example, if you are a national of your one country that's listed on the travel ban, even though work visas are not being contemplated now for most of those countries, make sure that you use the other passport to be added to the H-1B lottery. The second important point to look for is if you have been in the US, even now or in the past, with an L visa or even an H-1B, and then you have run out in time, you're gonna not be qualified for the H-1B most likely. So the time that you have spent in the US with an L or H-1B, depending on how much long ago, or if it's now, you might just have a few years left or no years left under the H-1B visa. So any time spent in the US with an L will count towards the time that you have under H-1B. The third important point would be you as the employee, you're not gonna be involved in the registration process because this is a process that is conducted, it's owned by the company. Us as the attorneys, we're gonna be sending you just emails with when we reach each milestone. All right. So, but once we get the documentation that we need from you, you're not gonna be reviewing, for example, the registration forms and so forth. This is 100%. This is a job that is 100% handled by the company. In order to qualify for the H-1B, you need to have the equivalent of a US bachelor's degree. So you can have, for example, a bachelor's degree, you can have a master's degree, you can have a doctorate degree. However, if you have an associate's degree or even let's say a bachelor's degree that it's that was just the duration was just for 3 years, for example, and that bachelor's will not be considered equivalent to a US bachelor's degree. It would be equivalent to an associate's degree. You can still qualify as long as you have enough experience. So the rule is for every 3 years of experience, you have 1 year of educational level. So if you have an associate's degree, for example, that would be equivalent to 2 years of college, you need at least 6 years of experience to have the equivalent of a US bachelor's degree. Or in the other hand, if you just have a high school diploma, you're gonna need 12 years of experience to qualify for the H-1B. As I said, it's in order to qualify for the H-1B, it's not just a matter that you have the equivalent of a US bachelor's degree, but the position also requires that level of education as a minimum requirement. The degree must be related to the position. So, for example, I will give you, of course, an example that is very extreme, but it's gonna be easy for you to understand. But let's say you are offering a position for an engineering position, and then the candidate only has a business degree, for example. Most likely, if it's not an engineering position that requires, for example, sales or marketing, something related to something that the person learned during, while attending that business degree program, then that person would not qualify for that engineering position. So it's very clear cut when we talk about you being qualified for the position, as long as your field of education, your field of expertise is related to the position being offered. If you qualify under the advanced degree cap, make sure that that degree, in order to qualify for the advanced degree cap, the university that issue your degree is non-profit and it's are accredited by the US Department of Education. All right. So those are the two minimum requirements to check whether the your degree will allow you to fall under the advanced degree cap. And why is it interesting to apply for the H-1B and the advanced degree cap? Because your odds of selection will increase. As I said, there are 85,000 H-1B visas that can be issued per year. Out of those 85,000, 20,000 are set aside just for those individuals that qualify under the advanced degree cap. Thus, you're gonna have the chance of running not only into the advanced degree cap, but also under the regular cap. And that illustration will show you what are your odds of selection based on the salary that it's being offered to you. Now, remember that I said that the company cannot tailor the job description to meet your qualifications. And the reason for that is the government can look into what other companies and the industry require for positions like yours, and then if the requirements for your position are much higher than what other companies are requesting, the government might think that position was tailored and is suspicious, and the company is only doing that to increase your odds of selection. That's one of the things that you have to watch for. The other things that you have to watch for is if the position, for example, requires some of education or experience that will make that salary level, the wage level, way below of what the company is offering to you, and the company is just offering that higher salary, so your odds of selection also increase. This will be a problem when the government analyzes whether your position qualified under that odds of selection. So those are the two main problems that I anticipate that will happen during this cap season. The government will actually look into what are the minimum requirements for the position, and then the complexity of the duties, and if they meet that that salary level. So just for a quick explanation of what this table says, um, the way the company and the attorney will determine what's gonna be the salary level, it's based, of course, on the job description. So once we look at the job description and then we look at the employee's qualifications, we're gonna look at the SOC codes. So the SOC code is a code that the Department of Labor makes available to the public, and it's basically broad job classification. So you're gonna have, for example, lawyers, dentists, you're gonna have a specialty of dentistry, you're gonna have lawyers, you're gonna have engineers, a specialty of engineers, financial analysts, and so forth. So many job classifications. So in order to qualify for the H-1B as a specialty occupation, that position has to fall under an SOC code that it's under job zone 4. That's the first thing that we're gonna have to look at. So job zone 4, positions in job zone 4 are positions that require at least a bachelor's degree as the minimum entry. Then from there, we look into where the employee will be working. So the salaries will differ based on MSA, which are metropolitan statistical areas. So, for example, you can have a mechanical engineer working in San Diego, and then you're gonna have another mechanical engineer working in Florida for that same company. Those salaries level will differ, all right? And then once this is determined, we go into the registration form, and then we say this is the SOC code that the person will fall, and this is the wage level. So based on that, the government, of course, based on the number of people that applied last year, This is the percentage of selection based on salary wage that the government anticipates that will happen. So if you fall under a level 4 wage, your chances of selection are about 60%. So it doubled from last year because last year everybody was under 27 to 30% odds of selection. Whereas if you are under a level 1, your odds of selection decrease, of course, by half. I mean, by half, because you are now with only 15% chance of selection. All right. Now, why is it important to plan now before we even add your name into the registration pool? Because the registration information will be used throughout the whole H-1B visa process. So we cannot say that when we submitted the registration, you were under level 4, and now we look at the job description. We believe the job description, the requirements do not meet level 4 wage, and then we wanted to switch to a level 3, for example. This is not going to happen. This is not possible. So in order to avoid a request for evidence, a notice of intent to deny, or even a denial, we will make sure that that job description meets that salary level. Then, of course, looking into whether there would be any pushback as far as education evaluation and whether you indeed qualify under the advanced degree cap. All right. Also, if you have any problems with criminal or immigration violations, this is the time that you have to let us know, because then we can look into whether you're going to be eligible to change your status in the US, or if you're going to have any issues when applying for a visa abroad. If you were selected in the H-1B and then you are looking into your max out time and you are reaching that max out time, is the time to also prepare for the future and apply for a green card. That's the time to start thinking about the perm. And also, if you don't have a job offer, look into an EB-1A or an EB-2 national interest waiver. Or if you have the $1 million to donate to the US, the golden card. And also look into backup options, because we know that the odds of selection are not super high for some people, especially the entry level positions. So look into other options, such as if you are an Australian, looking at an E3. If you are from Canada, maybe a TN, and so forth. So that's the time to start planning your future in the US. And that $100,000 fee that came last year on a Friday evening, that nobody understood what Mr. Trump wanted to say. But then later on, we have seen some progress, of course, and we know what exactly that $100,000 fee means, and who is going to be obliged to pay that fee before being able to get the H-1B visa. So that H-1B, that fee of $100,000 only apply to people applying for the H-1B for the first time. So if you are applying for a renewal of your H-1B, that $100,000 fee does not apply. If you are applying for the H-1B for the first time and you are filing a change of status, meaning you are in the US, you request to change whatever status you have now, such as an F1, for example, an L1 or a TN, and you file for a change of status, so your H-1B can become valid on October 1st. You are not required to pay that fee. However, if you filed your H-1B, a new H-1B petition for consular notification, meaning, let's say, even if you are in the US, but then you don't have the luxury of staying put in the US until the H-1B petition is approved. And then you have to do consular filing, meaning getting that H-1B petition approved, going through the consulate to get the visa, the $100,000 fee will apply. You are only required to pay that fee if the H-1B petition is approved. And once you go to the consulate will require proof of payment of the $100,000 fee. You only pay that fee once. So once you pay that fee, and then 3 years from now, you are now renewing the H-1B visa, then you don't have to pay the $100,000 fee. Now, some people will think about coming to the US, let's say by beginning of April, once they know that they were selected in the lottery, to avoid the payment of the $100,000 fee, to file for a change of status. If you are in the US with a visa that is not considered dual intent, for example, a TN or an O is a semi-dual intent visa, so I'm not going to include on that, but let's say a TN or an F1 or even like a business visa, make sure that you come to the US at least 3 months prior to June 1st. So what I'm going to tell my clients is that our deadline to file, to not file, but at least like June 2nd will be our final date to start thinking about filing for a change of status. So we have some wiggle room until June 30th, if anything goes wrong. So if you have a type of visa that does not allow dual intent, so any type of visa that is not an L or maybe an O, make sure that you come to the US beginning of March. And the reason for that is there is a rule called 90-day rule that says if you come to the US and then within 90 days you act in a manner that it's not in connection with the purpose of your visa, there is an understanding that you committed fraud when you enter the US. So we want to avoid that mishap. Make sure that the 3 months passes when you file the H-1B petition with USCIS. If you enter the US with an ESTA, which is the electronic authorization for individuals that are visa exempt, you cannot change your status to H-1B inside the US. All right. Once you go through the H-1B visa process, as I said, you have 3 main steps, right? Which one is the lottery process, the other one is the filing of the petition with USCIS, and the third one is the filing of the visa at a US consulate. You're gonna have costs as far as attorney's fees, government fees, premium processing fee, which is considered a government fee, which is optional, then the MRV fee, and then costs with translations and education evaluation. What's better, change of status or consular processing? Of course, if we are now we have the $100,000 fee that would apply. I would say change of status is the way to go, but not everybody would qualify for a change of status, right? So especially now under this current political climate that we have seen the government issuing travel bans, especially impacting people applying for visas abroad, and also the government putting more cases into administrative processing. We still have cases, for example, from last year that you applied for H-1Bs, the petition was approved by USCIS, but now they are stuck at the US consulate because they are running extra background checks. So that's what's going on now at the consulate level. So my preference usually would be filing for a change of status. Once you apply for your H-1B visa petition, USCIS can take anywhere from a few weeks to 8 to 10 months to make a decision on your H-1B petition if you don't pay a premium processing fee. So if you are someone that has commitments outside the US and must travel for work, then thinking about the premium processing is the way to go. And bear in mind that once you file the H-1B visa petition for change of status, even if you travel outside the US after the H-1B visa petition is approved, but it is before October 1st, you don't have to worry about paying the $100,000 fee. What triggers the payment of the $100,000 fee for people that applied for a change of status, but that then left the US before a decision was made. That's what's going to trigger the payment of the $100,000 fee. And once you go to the consulate to apply for your H-1B visa, as I said, if your case is not put into administrative processing, usually within less than a week, you should get your passport back with your H-1B visa on it. But if your case is put under administrative processing, the timeline varies a lot. It can take anywhere from a few weeks to maybe 1 or 1 year and a half until the consulate can make a decision on whether to grant you a visa or not. This is how the H-1B visa process works, and that's how we conduct like all the communications with the company and the employees. But we basically add your name into the lottery pool. Once you are selected, we work with the company to create your labor condition application and then file with the Department of Labor. It takes a week for the Department of Labor to certify the LCA. We receive the LCA back, create a public access file for the company, and submit your application. Usually, through my USCIS, unless you have dependents to be added to your petition, then in that case, we're going to have to snail mail that to USCIS. Then USCIS will make a decision. Once that decision is made, if you are of course in the US and not traveling outside the US by October 1st or at a later date once your H-1B petition is approved, your status will be changed automatically. But by the time you leave the US, and that's after October 1st, and then you are coming back after your H-1B visa petition was approved, and after October 1st, we still have to go to a consulate to get a visa to return to the US. However, don't worry about paying the $100,000 fee because you were approved for a change of status. If you are approved for a consular notification, you have you can apply for a visa 3 months prior to October 1st. However, you can only enter the US within 10 days of October 1st, or if it's after October 1st, you can enter at any time. Within 30 days of entry in the US, the company shall put you under its payroll. You should be paid as a W-2 employee, so it's easier to justify the employee-employer relationship. The company will be required to collect taxes on your behalf. However, you're going to be responsible for paying your own and like filing your own income taxes. The petition filing deadline to add your name to the lottery pool, it's going to be most likely third week of March. And to file the petition, it's going to be June 30th of 2026. But remember, because we need to receive the labor condition application certified before filing the petition. So we need at least 1 year, I'm sorry, 1 week of wiggle room before filing the petition so we can work on the LCA. Is it possible to file the H-1B petition while the J waiver is still pending? So if you are filing for a change of status, no. All right. So if you are filing for a change of status, you cannot. But if you are filing for a consular notification, yes, because you're gonna have to show that you are the 2-year home residency requirement was waived by the time you apply for your visa abroad, but you can apply for the H-1B petition with USCIS. If you are if you are in the US with an F1 visa and you still have your STEM OPT valid, in case your H-1B is denied, you are able to return to the US. Just make sure that your DSO is aware of that and that you were not put into cap gap. All right. So make sure that you maintain your STEM OPT valid until the H-1B is approved. I will talk about the cap gap in a few minutes. You can enter the US with your H-1B, as I said, at least 10 days prior to October 1st or anytime after October 1st, which is when the fiscal year for immigration starts. Your dependents can come with you, and they will hold H-4 visas. They will be able to go to school. However, they will not be able to work in the US. Spouses will be eligible to work in the US just in case you have started the green card application and you have a valid and you have an approved I-140 petition. All right. Now, self-sponsored questions. So last year, even though the H-1B visa always allowed people that own their companies to apply for their H-1B visas, it was not super popular until last year because last year the government issued regulations specifically covering or clarifying when the H-1B visa petition is an option for self-sponsored individuals. So the qualifications are the same, right? The position would have to require someone with a US bachelor's degree in a specific field, and then you have those qualifications. What you cannot do is you cannot have more than 50% of your duties that are related to the operations of the company. You need to have at least 50% of your duties related to the position, the technical position, the professional position that is being offered to you based on your technical qualifications. And then I would say at least 51% in that case, just to be sure that you're not going to have any issues with USCIS when you say that 49 or even lower than 49% of your duties are related to the operations of the business. It can be a startup company. We haven't received any type of request to show the company's ability to pay the offer salary to self-sponsored employees, at least during last year's cap season. I don't know if this is going to be a requirement this year, but so far we don't know yet. So when you ask whether the company must have a specific number of employees or if the company must have received some type of investment, the answer is no. Any company shall qualify as long as you have an employment identification number. In that case, the company. Is the chance of approval lower because the application is self-sponsored? I wouldn't say so. It really depends on how the petition is structured. And what I can tell is that we had a very high success rate based on last year's cap season for our self-sponsored individuals. So far we have had 75% of approval rate, and we still have one case pending. So that number can increase. How long is the petition valid for? It's once you file the H-1B petition and you are not self-sponsored, the petition is valid for 3 years and then you can extend for another 3 years. However, if you are self-sponsored, the petition will be valid for 18 months and then you can extend for another 18 months. And then after that, you're going to be able to extend for 3 years. Um, and then I covered the approval rates for that, and then I will share with you some examples of the cases that we worked on last year that were successful. One of them was for an engineering manager that opened a company to work with electrical utilities company. The other case is for an individual that has a business degree and she was opening a company to provide car rental services. And the third one that, I mean, those are the ones that are fresh in my mind. She worked as project manager for a company. However, the company did not want to hire her directly. So she opened her own company to provide services as a project manager, and in her own company sponsored her for the visa. Um, is there any specific area job position that is best for self-sponsored cases? Not really. No, I think we can be creative and work on the options that we have from the job classifications that the Department of Labor provides. Any company service that it's best, same response, as long as your education and your experience is related to the services or products that you're going to be working with. We can use our creativity to put our winning case. Is there any risk if you go through the consulate to receive the visa? What I can tell you is that our experience has not been um, pleasant with the visa applications for self-sponsored employees, the ones that got it approved. Some of them are stuck outside the US under administrative processing. So I'm telling my clients that it's best to stay put in the US and don't go through the visa application process if you are self-sponsored. What corporate documents do we need? So to start with, right, just to put your name under the lottery, we're gonna need proof of the EIN creation. And then we look into the job description documents and so forth. So you're going to be answering more questions. But then once you go through the filing of the petition itself, we might receive a request for evidence, for example, requesting a business plan or requesting copies of the bank statements, copy of contracts with clients. So those are some of the documents that we ask our clients to start preparing in case we receive a request for evidence. But from the get-go, to start with, just the EIN confirmation letter. You don't need a business plan if the company was recently created. However, I highly encourage you to have one because it's very I would say naive and amateur if you open a company without researching the area where you are located, as well as who are your competitors, how much money you're going to have to invest, and so forth. So I highly encourage to have a business plan. And how can I demonstrate my ability to pay if I just created a company? As I said, this is not a requirement, but we should be prepared to answer those questions as they come. I would say that it's good to make an initial investment and open a bank account for the company and put this money there. The amount of investment will really depend on the type of company that you have and also that study that you're going to make on to create the business plan. Now, if you have an F1 and if you have an OPT or if you are under the grace period, you need to understand a little bit more about the cap gap. So what the government says is if you have an F1 status, right? And your employment authorization document is about to expire, as long as that H-1B visa petition is filed before the expiration of your employment authorization document, that employment authorization document will extend automatically until the H-1B petition is approved or until April 1st of the following year if that H-1B visa petition is not approved. All right. If you have an F1 status and your employment authorization document already expired and you are under your grace period, once you file that H-1B visa petition, you're gonna also be allowed to remain in the US. However, you are not gonna be allowed to extend your employment authorization document. All right. So this is the first question. Here is an example. Let's say I have F1 status and my OPT expires on May 25th. Will the cap gap provision apply to me? The answer is yes, as long as your H-1B petition is filed before May 25th. Your cap gap will start on May 26th. And if your H-1B visa petition is approved before October 1st, your cap gap will extend until October 1st. However, if your H-1B petition remains pending, your cap gap will extend until April 1st of the following year or until the H-1B visa petition is approved if it's before April 1st. Make sure that you communicate that to your DSO at your school so they can properly add to your CVS record, your I-20, that cap gap provision. Now, you're not going to be able to travel while your cap gap is ongoing, while, of course, your H-1B visa petition is pending. Um, the other example that I have here is I have an OPT. Can I continue to work if my OPT expires before my H-1B petition is approved? The answer is yes. It's as long as the H-1B visa petition was filed before your OPT expires. That's the case. You don't need to apply for an employment authorization document with USCIS. Your employment authorization is automatically extended. All right. And if my OPT expires before my H-1B petition is filed or before the start of the H-1B period, which is the lottery, right? Am I eligible for cap gap? Yes, but as I said, your employment authorization will not be extended, just your ability to remain in the US legally. You don't have to apply for that cap gap extension. This is going to be automatically done by your DSO once you provide a copy of your H-1B visa petition receipt notice. Just repeating myself, the cap gap will be valid until October 1st in case your H-1B visa petition is approved before October 1st or April 1st of the following year, in that case, April 1st, 2027, in case your H-1B visa remains pending. And that was it. That concludes my presentation. I'm all ears and I'm here to answer your questions. Do you have any questions?
Yes, I wanted to ask a question. Very nice to meet you, and thank you so much for this presentation. It was very insightful. My question is, saying you go through the process, you have been approved to work for that company, but then you decide to work for another company. Does the company that you go to need to sponsor you again, or
Yeah, they don't
how
have
does
to,
that work?
you don't have to go through the lottery process again. However, they have to file an H-1B petition for you for concurrent employment.
Okay.
So you're gonna have two petitions, two valid petitions, one with your current employer and the other one with the new employer. And
Okay,
then if
so
they, uh-huh.
sorry, go ahead.
And then if the conditions of your employment with the first employer changes, right? For example, you were employed as a full-time employee and now you are employed as a part-time employee, that first employer will also have to amend the petition. So if there
Okay.
is any material change to the conditions of your job, then the employer will have to amend the petition.
Okay. Thank you. I might just follow up with a second quick question that I
Sure.
just remembered. Um, Again, saying you were approved and you worked those 3 years and you want to apply for the green card, does the company have to sponsor you for that green card, or can you do it yourself? What are the paths for?
So you can self-sponsor your green card and if you qualify, right? So we have basically two types of green cards that you can self-sponsor. One is the EB-1A for extraordinary ability individuals, and the other one is the EB-2 national interest waiver, also for exceptional ability individuals. Otherwise, if you don't qualify under one of those two options, then the company would have to sponsor your green card. And in that case, I was like entertaining some questions before we started the presentation, but the position of the green card position will have to be related to the H-1B position
Okay.
because it's the same employer that it's sponsoring you.
That makes sense. Thank you so much.
Hi, Bruna. We do have a couple questions in the chat, so I'm gonna read it for you, okay?
All right.
We have a few ones. So the first one is, what if I enroll the lottery through an employer and before being selected / approved, I change my employer? What if I decided to change employer after being selected, approved?
Okay, so let me answer that one first. Then in that case, you're not gonna be able to file the petition because the selection is company related. You can have, for example, several employers adding you to the lottery, but your chance will not multiply based on number of employers that add your name. So you're gonna run just as a person. And then if you are selected, all those companies can file your H-1B petition. But if that company is no longer willing to sponsor your H-1B visa, then you are out of luck.
Okay. Do you want me to repeat the other one?
Yes, the second question.
Well, okay. What if I decided to change employer after being selected, approved?
Then in that case, you can, if once you have your H-1B petition already approved, you can change employers and you don't need to file and you don't have to go through the lottery process because you were already selected.
Okay, there is a couple more from him. Do I qualify to be clear to pay the H-1B 100K fee?
So if you file for a change of status from O1 to H-1B here inside the US, you don't have to pay the $100,000 fee.
Okay, so
who pays the fee, the employer or the employee?
there's another
It's
one.
the
So
employer.
who pays the fees?
Yeah,
The
that's the
employer.
employer.
Okay, there's another one. If I leave USA with my H-1B approved, do I need a visa stamp in my passport? For how long usually this visa is valid?
So yes, if you are not Canadian, right, which is the case, if you leave the US and then you were approved for a change of status and you need to return to the US, you need a visa stamp. Yes. And the visa validity is based on nationality. So the visa will be valid for either the validity of the petition, which is up to 3 years, or the validity based on your nationality, whichever is shorter.
Okay, another one from him. Do I need an LLC or similar to be self-petitioner? If yes, I'll be hired as a 1099, not a W-2, right?
So The company must have an EIN, so it can even be sole proprietor. It can be like a DBA. Usually, right, for malpractice protection, it's in liability protection, it's better to have a legal entity, to create a legal entity. In that case, an LLC. Yes, that's the recommendation. And then as far as payment, I would usually, and it's even good for tax purposes that you receive a salary with a W-2. But yes, I would say for employ to prove that employee-employee relationship, having the W-2 is very beneficial.
Okay. Now a question from another person. Just to confirm, the cap gap only applies to people who were chosen in the lottery, right?
Correct. Not only chosen, but that the petition, the H-1B petition, was filed with USCIS.
Okay. One from Camila. Hello, Bruna and team. Hi. Do you have experience handling H-1B process specifically for physicians? I noticed that the process is a bit different. So she puts something else here, so I'm gonna read it. Based on the presentation, I understood that the 100
No, she said that
thousand fee would be not
$100,000 will
applied when
apply.
filing in H-1B as
Yeah, go ahead.
well, okay. So, okay, change of wouldn't be applied when filing a H-1B as change of status from J-1, while in the US, if the person travels, if the person later travels to Brazil and needs a visa stamp, would that change the fee applicability in any way? And any and
And that's
does
the
the
same
same
logic.
logic
Mhm.
the same logic apply to does the same logic apply for a spouse changing from J2 to H1B or from J2 to H4?
Yes, so once you have that petition approved for a change of status, the petition will say that you are not, that you don't fall under the people that are obliged to pay the $100,000 fee. So if you go later to the consulate to apply for the visa, then you don't have to pay the $100,000 fee. Okay.
Okay,
And
this
the
But
$100,000 fee, it's just for the H-1B visa holder, not for the H-4.
okay, so she has another one with premium process. Once the H1B is approved, 15 days is it is generally safe to travel internationally from visa stamping.
So it really depends, right? I would say that since you are a physician, you're probably gonna be working in a hospital or right, or a clinic that has a relationship with a hospital. So I would say it's very unlikely that your visa application will be denied. So I'd say it would be safe for you, but I cannot say the same for other individuals. And yes, we process H-1B for physicians, and sometimes you can even qualify for the H-1B under the CAP exempt provision.
we have a question. How to
Mhm.
determine exact SOC code for the job if the job responsibilities match multiple SOC codes?
That's a good question. What I usually do, I look into what are the company's products and services, and then determine if it's and it's very common for T-Mike specifically because I know you work for T-Mike, between electrical and electronics engineering. So I'll look into usually I go with electronics engineering because the wage levels are lower, a little bit lower than electrical engineering.
Okay, the next one, is the cap gap only valid for OPT and not for CPT?
Correct. So if you only have a CPT, that will not give you the option to apply for the cap gap. So it's basically you have to keep your CPT valid.
The next one is in case my employer wants to transfer me to another place and other company from the same group, do I need to go over the lottery again? How long it would take to change the employer?
No, you don't have to go through the lottery again. So once you have been selected in the lottery for a change of employer, amendment of the petition, all of that, you don't have to go through the lottery again. But the new employer will have to file a change of employer petition with USCIS. And that takes, if you file with premium processing, within 15 business days, you should receive a response. If not, between, I would say, 4 and 10 months.
We had another question prior to the first one we read about associate degrees. So, how about associate degree? Can I get it qualified?
Mhm. So just the associate's degree, no, you need to combine years of experience with your associate's degree. In that case, you're gonna need 6 years of experience plus your associates to get the equivalent of a bachelor's degree.
And then the last one. So, are there chances that level 4 candidate gets selected more than one entry? And how does it work?
Yes, so right now the prediction is that level four candidates will have a chance of 60% of selection. And if you fall under the advanced degree cap, that odd will even increase. So it's just like being added to the lottery 4 times.
Just sent a new one. I am in the US with a B2 status. Am I eligible to apply for the H-1B? And if approved, is the 100K fee applies since it is a change of status?
So you can apply for a change of status with your B2 status. Just make sure that you apply before your I-94 expires. And you're gonna have to also request an extension of your status because the government wants to make sure that you have a status um, all you have like a streamlined status, right? From the time your until the time your H-1B is triggered. So let's say your I-94 expires in May. And we know the H-1B, if approved, will only be valid starting October 1st. So you're going to have to file an extension of your B2 status to cover this gap. And then that's when it becomes tricky because as a tourist, you have to show that you have the intent to return home, right? Once your tourism activities end. And then having the H-1B petition filed means that you're going to remain in the US for some time. So that's tricky. But you can, right, in theory, and you don't have to pay the $100,000 fee because you are applying for a change of status.
The other question, the last one, she says that she currently has an EB3 process underway with INLG and wanted to ask how we can begin discussing the possibility of pursuing an H-1B as well. If we could let her know the next steps, and she wanted to evaluate this option.
You can reach out to us via the WhatsApp group that we have with you, or even via email. And we have Bruna Viana from our team. She's handling the H-1B calls, and then she can talk to you about it.
I think this is it. If we don't have any additional questions, as Attorney Bruna said, we are more than happy to provide any sort of assistance if you are interested in the process. Uh, the next slide has our number, Attorney Bruna, if you want to move on. Please feel free to reach out to the team on this. This is a WhatsApp and a phone number. This is also our Instagram where we share invites to events like these, and we are 100% available if you want to move on with your H-1B application. We would be glad, Attorney Bruna, I'm sure, would be glad to represent you in this journey. Thank you so much for all of your attendances.
Thank you
Have a
all.
great
Stay
day.
warm.